Well, hello everyone. John Miller, founding attorney of Rock Solid Law, Rock Solid Title. Man, today we're going to talk about one of my favorite subjects. So thank you all for joining me. What a beautiful sunrise this morning. A little chill to the air, feeling good, feeling frisky, feeling ready to make some changes in the world to help some people out today. And I hope what I'm going to talk about will be meaningful to you guys because it's literally part of my quest, part of my ministry of my firm. The reason I created the firm is to help people avoid probate and to help support American families, Florida families. And that's one of our areas of expertise. And just one of my passions in the practice of law is to see my clients pay only the mandatory taxes to our federal government, to the IRS, and to share absolutely as much of what they worked for and show their love to those they treasure through the estate planning process. So obviously today we're in this estate planning area of my law practice. Most of you, I believe, are already familiar with the firm, but we also handle closing, title, and escrow of residential and commercial real property. That means when you sell your home, we can help you. We can also help you with business property. We can guide you through that process, whether we're handling the closing or not. But of course, we'd love to handle it. I've got a wonderful real estate department for that. I believe that home ownership is the cornerstone of the American dream. I also know that small businesses are the heartbeat of our American economy. And those of you that know me well know that I came up as a business litigator, moved over 25 or so years ago to more of a business transactional practice, and have loved representing small businesses from then to now. Got a couple new ones this week with some exciting projects ahead that I just love being part of. And as a part of that practice, when I came to the beach in 1991, that's right, 30 years ago, my clients got smaller. I was representing big corporations in downtown Jacksonville, and then there's 1, 2, 3 people owning a business. And so I learned rapidly that I couldn't serve them as well as I wanted to in making decisions for the future of their businesses without helping them make decisions for the future of their families. And the part of the law that's called is estate planning, which makes absolutely no sense to me, but the divorce lawyers stole the term family. And so I can't claim that I'm a family lawyer, although my practice is not aimed at splitting families apart. My practice is aimed at multi-generational family planning to keep families together, because I believe that the nuclear family is essential to our American culture and to the flourishing of the future generations of this country. You can see from the pictures above and behind me, obviously family is something that's really, really important to me. And that's what today is all about. Even though it's called funding a trust, it's not about the rote act of that very important aspect of having a trust and avoiding costly and delays in probate, but it's about really funding means making it easy, hitting that easy button for those people you love for the point in time when you're not able to manage your affairs, and also the point in time when you're no longer here to really care about anything more than knowing that they were handled properly. So the first question in this discussion from my perspective as a 37-year practitioner is, have you taken the all-important step to get rid of the unnecessary cost, delay, publicity, family fighting, etc., that happens when someone dies and their estate goes through probate, right? That's the stepping off point here. Because if you're just fine with there being a delay when whoever or whatever you love gets what you leave behind, if you're just fine with that being public record at the courthouse, if you're just fine with that being significantly smaller than what it started with, if you're just fine with paying appraisers, accountants, lawyers, a bunch of money after you're gone, then this isn't for you, right? If you're fond of giving the government too much, then you can just jump off this call right now. I'm kidding. I hope none of you will, but that's what we're really talking about, because the first thing in your mind is, wow, what estate planning can do for you, for me, for you, is keep what you have earned in your lifetime in the pockets of those you love the most, right? So we want you to get rid of delay. How do you get rid of the delay that comes with probate, with the cost that comes with probate, with the fighting that comes with probate, with the litigation that comes with probate? I hate litigation. I really do. We can talk about that another time. Sorry, litigation lawyers that I refer to, but I'm glad you're around, but I don't like feeding you. Funding is all about avoiding the diminution of the value of what you've worked for. And we do that through a simple living trust, okay? A living trust and a will, in that case, a pour-over will, are the cornerstones of your estate plan. And having that living trust means when you're gone, no judge who was probably appointed by some politician is in charge of deciding who gets what, when, and how little of it actually passes through. Okay. So there, you got to have a trust. But guess what? And this, I am angrily passionate about this. Okay. People go to lawyers who draft a pile of papers that people then sign and think that they've accomplished something. That pile of papers goes in a desk drawer, and that pile of papers does absolutely no good unless the next step is taken. And the next step is funding. And in less than 20 minutes, you're going to know what that means. And you're going to be able to make a decision whether that's what you want for those that you love. Okay. So, and you're going to find out why I'm violently or angrily passionate about this. Funding simply is retitling your assets under the law, so that they belong not in your individual name or that of you and your spouse, for those of you that are married, but in the name of the revocable living trust that you own and have complete dominion and control over during your lifetime. Okay? Essentially, funding is taking everything you've got out of your left pocket, put it in your right pocket. Why do I throw that in at this point? Because you can still spend it no matter which pocket it's in. All right. Complete control. No asset protection with a revocable living trust. You have to relinquish some control to get asset protection. We'll talk about that another time. Okay. Today, we're just talking about transferring into that trust. And that's what, for some reason, estate planning lawyers somewhere along the way decided to call funding. Because a trust is a sad little pile of papers if it doesn't own anything, right? So you'll notice that when we draft a trust, we put something in there, $10 to start, because that breathes life into it and it becomes a living entity, right? Living, breathing entity. It becomes a real deal that then you can think of it as a basket, and the funding is depositing everything in there. Yep, we're going to retitle your bank account, and you're going to still be able to spend all the money in, right? According to federal law, we don't retitle your retirement accounts or your life insurance policies, but we make the beneficiary of those the trust, so that you write the rules about how it's distributed and how quickly after you don't need it anymore. Okay? So funding of the trust is nothing more than retitling your assets so that they are held by that trust. Okay? So that the trust is the owner of the assets and you absolutely lose no control over it. You still exert complete control over that. Okay? So why? Why would I want to go through it? Isn't that a pain? Sure. It's taking care of some details, but how hard is it to get the right form from your financial planner, from your broker, from your banker, from your life insurance person, and transfer those titles? My experience tells me it's really, really hard. Sarcasm font. You want to know why I say that? Because for years, I helped people get trusts. And for years, we called them and said, did you move everything into title? And for years, they said, mañana, I'm going to get to that next week. Right? And then I have people come to see me whose lawyers didn't even tell them to do that, who gave them a piece of paper that gave instructions on how to do it in the same pile of papers in a notebook where the trust, the will, the power of attorney, the living will, the healthcare surrogate, blah, 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 all that stuff is in there. Do you think they read it? No. And if they did, do you think they did it? No. So what do they have? They got a pile of papers because they didn't fund the trust. They didn't transfer the title. So I just kind of mentioned to it, what are the steps? Easy peasy. With us, the steps are getting on the phone and my team tells you what they need to help you get through this process. If you're going to do it yourself, we will give you an instruction manual and then we're going to badger you. You go on our nag list. That's right. I have somebody that's going to call you and say, did you do it? Did you do it? Did you do it? Are we there yet? Basically, right? Who's got kids? Are we there yet? We'll be asking you that and you'll be going, I'm going to get to it. I'm going to get to it. It's number 17 on my list of to-dos, right? So the what are the steps? Or you can do it yourself. You can. People don't. People don't do it. I've been doing this a long time, people. I graduated from law school in 1985. Okay? 1985, yes. I have the experience to tell you that very few people will do it themselves. And so, therefore, in every estate planning package that my firm provides, we include the funding of the trust in it. Okay? What's that mean? That means part of your fee covers us helping you get that done because it is just that important. Because without it, you got a pile of papers with some ink on it that you paid a lot of money for. Too much money in that case because you didn't get the value. When you leave my firm, we want you to have the value. Okay? So we're going to help you take the proper steps to move your real property as appropriate and your financial holdings as appropriate and anything else that needs to go in there. So it is completely controlled by the trust, of which you are likely the trustee. And then after you can't do it yourself anymore, either because you got diddly and you appointed somebody else to do it, or you're gone from this sphere, somebody else immediately takes over and carries through a fiduciary duty on as trustee according to your instructions. Okay. And that's called trust administration. We'll help them too if you want, but that costs a ton less than a probate, right? People ask me, why are some firms probate kings? Do they call themselves probate kings? No, they don't. Do we all know who they are and know that they are probate kings? Yes, we do. You want to know why? Because it's lucrative. Lucre. It's lucrative. They make a lot of money. And so think about this scenario because it's happening all around you and it's happening at places that everybody says has an excellent reputation because nobody knows what's going on. They will sell a plan of well-crafted documents to a person, and they will get them to sign them. They'll pat them on their head and they'll tell them how very good and responsible they are for actually taking care of their estate planning. And then they'll send them out in the world. And then with a little piece of paper that says, make sure and move all your accounts over. With a little piece of paper that says, make sure and move all your accounts over. And nobody follows up. And nobody makes sure that those accounts have been moved over. And you want to know why? Why? Because they've just charged a nice fee to provide that work, as well they should. And then after that person dies, the heirs are going to come back to that same firm because it's all they know. And they're going to go, oh gosh, we gave you this great plan, but she never funded it. He just didn't get around to funding it. So we're going to have to go through probate. Yep. Our firm just happens to provide probate. And it cost a little more than it cost to do the trust in the first place. So now you pay twice to get those assets to the next generation. And not only did you pay twice, but at the time when they should be celebrating you, at the time when they should be rejoicing about the way you just provided college for their kids or whatever you've done, they're involved in a lawsuit. They're not playing golf. They're not playing tennis. They're going to court with some lawyer they don't know and are mad at you for making them deal with. Okay? I grew up in the South. That ain't good. Got it? All right. There are a lot of law firms doing that. If that's your lawyer, I'm sorry. I could fix it. Right? And do I help people through probate? You bet I do. You bet I do. Anybody that we didn't get to during their lifetime and help avoid it, we're going to get you through there. And we're going to get you through there as efficiently, quickly, and with as little fighting, if we can help it, between the family as possible. We don't take intense litigation. So for those families that somebody's crawling out of the woodwork to cause a problem, probably going to refer those out. But if the family just needs to transfer assets from one generation to the next and nobody planned to keep them out of probate, we're going to do it. I see some questions coming in. I'm not even reading them quite yet, but I will in just a few minutes. I'd love to spend a few minutes with questions and answers at the end of this. And I believe those are coming in on that's the chat bar. So that is about right in here. So if you have something you want to communicate with me, feel free. And I'm going to read those in just a minute. I got a little more on my outline. So you see why I'm passionate about this? I'm passionate about this because I am an attorney. I committed my life to this practice. I wanted to be a rock star. It didn't work out that way. I still get to play some music on the side. Those of you that know me know that. But listen, I know the reputation attorneys have. Most of you know that my father was an amazing leader in the Presbyterian Church, a minister, a civil rights leader. Big shoes to fill. So while my brother followed his footsteps and I didn't, I think Fran is 10th generation in our family, ministers going all the way back to Scotland. I consider my firm a ministry where I try to make this world a better place through the community in which I practice. And part of the way I do that is helping families not fight and helping people give what they worked their whole lives for to who they want, without a whole lot of hassle or government involvement, okay? So yeah, I'm offended by those firms that do that to their clients, all right? So when you plan with us, we're gonna help you move your assets into that trust so it does what it was supposed to do. And when I say that trust, there's 1,000 different trusts. You're only gonna get the one that's best for you and your family. The B on that is if you're sitting there thinking, golly, that's exactly what my law firm did to me, I would love to review your plan. And we would love to assist you in getting your trust, your entire estate plan properly funded. And, if it's been a little while, we can update the plan for you as well. You don't have to stay with the lawyer that first drafted it. We know what we're doing. There are a ton of lawyers that know how to draft documents. The difference with what my firm is set up for is we actually want and have a stated goal of helping families. Would those lawyers tell you that they're probate kings? Would they tell you that you can pay them now and pay them later? No. Do they even think about that when they look in the mirror? I'm guessing not. But over time, that's what their practice does. Okay, so why is that bad? Because it costs you and your family money, right? Probate, by statute, the attorney owns a percentage of the value of the probate estate in addition to reasonable and extraordinary fees. Lawyers who practice in probate make a very good living. I'm happy for them. It's necessary. Our court system in America is the best in the world. But if I can keep my people out of it, I'm going to do it every single time. So my advice to people is pay now so you don't have to pay later, or your heirs don't have to pay later. Or if you want to put that burden on your kids, give them the choice of paying now so they don't have to go through that later. Or if you just can't be bothered with it, don't pay now. Let them pay later, right? Obviously, a little sarcasm there, not the best planet in the world. So I kind of jumped ahead because I care about it. We include funding in every package we prepare. I will let somebody talk me out of it, but then I have to nag them, and that's no fun. Nobody likes to be nagged. I'd much rather high five them after we get it done. The reason to do funding, the reason to transfer those assets is because it's what you planned. It's carrying out your plan. Anything legal, we can write it into the plan. Those kids cannot get the money unless they got a job. They cannot get the money unless they drug test, if that's what you care about. You can also give part of your money to charity. I love helping with that. Oh my goodness gracious. That's part of the best part of my job. So people sometimes ask, how much does that cost? Right? And I say, I can't tell you until I get to know you. And neither can any other lawyer. And lawyers that are out there quoting prices on the internet or over the phone, they're not telling you the truth. Because once you talk to them, the scenario is probably going to completely change. And I doubt seriously the cost they told you is going to go down. When somebody, typically somebody who has very little assets, needs something very simple done, we'll refer them to a quality lawyer who will charge them very little, right? It is, it doesn't, if it doesn't make sense for them to pay for the services we provide, I'll tell them. That's not a problem at all. But I will tell you, cost-wise, getting your entire estate plan in place is typically less expensive than a single 1-week family vacation, right? So how about that? You can take care of a big bucket list item, right? I got a client that will say, when I kick the bucket list item for less than a single vacation, will there be changes through as your life changes? Yeah, because your life's going to change. There may be some. If they're little teeny tiny things, we'll do them for you. If it's a significant change, you're going to pay an extra fee, but not much, right? Because we're going to update that just like you have to go have your car tuned up. Got to put gas in it. Got to fix it occasionally. Mine's in the shop this week getting a bunch of body work done. It's going to cost a lot, but I want it done because I want my car looking nice, dent-free, scratch-free. And it's going to. And that's worth it to me to pay to have that done. So when a trust has to be updated, when a will has to be updated, there's a cost associated with it, probably. But it's well worth doing and should be done, I'd say about every 3 years, or if there's been a major family development, like a birth, a death, a marriage, a divorce, getting rich, getting poor, big changes in economic status. Those kind of things require change. So circling back, funding. Funding is about transferring title into your trust, whether it be a revocable living trust or another kind of trust. Okay? I'm going to look at the questions in just a second. I have completely forgotten to look at what on earth I'm going to be talking about next week. Oh, yeah. Oh, no. Yeah, it's perfect. Week after next is Homestead. Everybody, I got to do that one several times a year because it saves money for people. But next week, we're going to talk about probate. People want to know about probate. You've learned a little bit about it. I'm going to tell you some more next week, Thursday morning, 9 o'clock. All right. I've talked a little too long. And so let's go see what these questions are. First, I'd like to get a gauge on the cost to prepare all this. The first question, I didn't even know that question was out there when I answered that. Less than a vacation. All right. So, depending on your needs, there are trusts that we prepare that are asset protection trusts, trusts anticipating tax advantages that save people hundreds of thousands of dollars. That can be, $10,000, $15,000 type matters. The standard trust that I've been talking about all morning today is probably, depending on if you're single, if you're married, what your situation is, and what exactly you need done, going to be somewhere in the $3,000 to $5,000 range ish. I will guarantee you that a formal probate of assets, which means anybody that owns more than $70,000 worth of something, going through the court is going to exceed that in cost nearly every time. There may be an exception that proves the rule, but your heirs are going to spend a lot more than you have. Let's see. Thank you for this comment. I have been through probate and do not want my family to experience that. I literally hear that every week. I most certainly want to have you handle all this for me. Yay! I'm 46 with a 5-year-old son. Congratulations, -7. Pretty important for me to get handled well. Look forward to talking to you soon. All right. Now, here's a great question. Joint or individual trusts? Ours are individual. Should we update them into one? You're going to hate this answer. It depends, right? I know there are attorneys that do individual trusts a lot. For a married couple, I prefer them to be consolidated into one. I believe that is easier on the heirs, for one, who may or may not be the subsequent trustee. But here's the real reason, right? I look at a trust arrangement between a long-term couple, and I will tell you guys, I'm not going to say who it is, but the person. Okay, sorry, I looked ahead and I just that nailed what I was looking for. Yay, everybody, high five. The person that asked me this question, I happen to know that they have a long-term, wonderful, committed marriage and children. So in that case, I look at, and this is, John Miller, rock solid law practitioner, I look at the trust as a contract between that married couple so that they decide together what they want to have happen after the first of them are gone, which is usually take care of the other one during their lifetime, which I'm sure what you guys are going to do. You know who I'm talking to. And then what's going to happen ultimately, so that after the first one's gone, it often becomes irrevocable. Why? The pool boy, the gold digger, right? A lot of people still want companionship after their lifetime partner is gone. Okay, cool. I've had people say, hey, I want you to have a good life. Just don't give away what we've earned together to anybody other than our kids. Fair enough, right? So the joint trust does that if we draft it that way. Could we draft it that way in individual trust? We could, but I don't know why people do. I do know there are attorneys that draft one for the husband, one for the wife. Maybe that's in anticipation of dissolution of marriage, divorce. I don't know. I actually called one because their client came to me and he had moved out of this jurisdiction. So it was totally legit that the client wanted somebody here, and no offense to him, it wasn't that they were unhappy with him. I tried to get him to explain his philosophy of doing 2 versus 1 to me, and he doesn't return my calls and letters. So I really don't know, other than if they are pre-planning for divorce, why that you would create separate ones. I love the fact that you make a deal together on how you're going to take care of your kids or whoever you love, and not leave it to random chance which one of you lives longer and changes the rules, right? I mean, rare is the couple who both love all of the nieces and nephews on both sides of the families equally, right? If that's, it's just an example of how it might play. So I much prefer the joint, and without knowing the actual facts situation, is probably best to combine them. And that's not rocket science. Well, it is rocket science, but I know how to fix the rocket. How about that? Should a primary residence have to be changed to a trust? Excellent question. And the way you put it, of course, isn't what do I recommend? It's does it have to be? So you've given me an easy answer. They have to be. No, it doesn't have to be. You don't have to do that. Florida has one of the strong, try that again. Florida has one of the strongest homestead laws in the world, right? It's a great thing. So we do nothing to screw that up for you, right? We want to keep your homestead protection intact. It's one of the greatest asset protections in the world. That's why a former Major League Baseball commissioner moved right down there to Ponte Vedra Boulevard, put all his money in his house, and declared bankruptcy, right? So that nobody could collect anything against him that he owed. I don't really approve of that as a strategy, but it's legal under the laws of Florida. So you don't have to change it into a trust, but why on earth wouldn't you, right? Because if it's owned by your trust, you maintain and done properly, underlined, underscore, highlight, bold, right? Because you can screw that up if you don't know what you're doing. If the homestead is put into the trust, then it passes immediately at the death of the second to the trustee, who is whoever you decided it would be. Likelihood it might be your heirs, right? There's no delay. There's no step up in basis, at least under the current laws. So there's every good reason to put it in the trust, and you get to choose what to do, how it's distributed at that point. Homestead, this is a little bit of a tangent, and I'm over time, so if you got to go, you got to go, but I'm noticing folks are staying. Thank you. Homestead is not part of a probate estate, and this is a whole big another subject I ought to hit someday. But to get it out of the probate estate, you got to file the probate and get a judge to enter an order saying that the homestead is released for the probate estate, right? There's good legal reasoning for that, but it's a hassle. And guess what? By putting it in the trust, we can completely avoid that hassle. There are other ways, other strategies, one of which might be an enhanced life estate deed. But if you have a trust, especially if it's a single trust owned by everybody who owns that property, that homestead, makes total sense to move it in there. All right. Oh, that's a thank you note. And I'm not seeing any more questions. Hot dog. Let's see. I see one over here. Whoop. That one requires glasses. Hey, this looks like a great question. What kinds of trusts are standard for a couple in their 60s with grown kids? So speaking as someone in his 60s whose kids are not quite yet grown, but will be, first, the caveat, right? Not knowing anything else about you, I can't answer the question totally, but probably the revocable living trust is the perfect basic building block trust for your plan with your adult children. Need to know a little more about those adult children and what your thoughts are about future distribution to them, all that sort of thing. I believe the question said you are a couple. I'm sorry, let me refer back to it. Yes. So the two of you might do a revocable living trust, which would then be funded, which is the subject matter of this discussion, with all of your assets, so that everything would be distributed according to the plan you set forth in that trust by the trustee you choose to do it. Who, by the way, if you are in the position that you cannot manage it yourself, will be responsible for handling your assets for you, even during your lifetime. So we avoid a lot of issues by that trust. Love to have a chat with you and go over that and make sure that's the best plan for you, because I can't say for sure without reviewing. So quick review. Thanks for being here. All of you guys that are on this Zoominar, if you need me to look at your funding or otherwise to review your existing plan, or even sit and talk with you about what kind of plan you might need, like that last question, I will toss out the consultation fee. I've done this 37 years, so I typically do charge $450 to sit with people. I will waive that for you guys that are on this call. Where are we? We're about mid-month up to the end of the month. If you will call, make an appointment, call today, make an appointment for whenever, and my amazing staff can schedule you to sit with me or another attorney in my firm, and probably me though, because I love doing consultations. It's just something I enjoy a lot. So there's my offer, my call to action for you. If you need to have your trusts blended into one, if you need to update your trust, if you need to talk about whether a trust plan is right for you, or even if it's only a will plan, we could talk about all that sort of stuff in that meeting. And let's definitely get busy and get it done. Oh, you are so welcome. I just, man, we started to not do these anymore because people aren't doing Zoom meetings as much. You know, year in, people are kind of, I don't know, not wanting to get on another Zoom call, right? But it is so thrilling to have these great questions, to get to share this stuff that that I've learned after all these years. All right, I got one more, and I'm gonna read this question. Oh yeah, totally. The question is, can you place homestead? No, ding ding. Zoop. When you place homestead in a trust, can you still file homestead exemption? Absolutely, if it's done right. Okay, it has to be done correctly. There's this, I like to say, magic language we sprinkle in it. We practitioners know what to do to make sure that your homestead is preserved. And I feel preserving homestead is one of the most important services we provide, because Florida homestead's an amazing thing. So absolutely, we put it in there, and you will still get your homestead exemption from taxes and your homestead protection from asset protection. Listen, if you go to Rock Solid Law /videos, there is a video in there about homestead, and it's well worth doing. I will be teaching another homestead one sometime coming up, because folks seem to like to have me do those live periodically. Not really sure when that one is, but next week we're going to talk some more about that subject of probate that we hit on a little bit. You guys, this has been an absolute pleasure. It is exhilarating for me to spend the time with you and share what we do and what we know. Hope I'll see some of you soon. All of you, of course, are welcome next week for the probate presentation, 9 o'clock on Thursday. You're already on the phone with my girls. Thank you. They're glad to hear from you. I'll see you soon. Here is Lionel Richie and the Commodores, who hail from my old hometown, Tuskegee, Alabama, with a song that I wish I'd listened to in my investment portfolio a year ago. Zoom. Have a great week, you guys. Be well. Be safe. John Miller.